This is an important ruling given that now the courts have some precedent to lean toward closed AI models. Welcome to Brach Eichler Talks. Today, more interesting information on the use of artificial intelligence in the process of litigation. Two holdings I want to discuss today. Morgan versus V2X Inc. It's a Westlaw citation, 2026-864-223. And the other, Jefferies versus Har Cross Chemicals, also Westlaw, 2026-820-218. Both interesting cases dealing with protective orders, litigants' rights, and the emerging issues that courts have to tackle concerning the use of artificial intelligence. Morgan is a straightforward employment discrimination case. Nothing unusual about the facts in the case. However, the court's analysis and the holding are important. The litigants are engaged in a battle concerning the use of AI as an emerging technology, the security concerns around the platform itself, disclosure potentially of confidential information, and also the disclosure of the name of the platform. In other words, the disclosure of which AI tools the party is using. The court had a thoughtful analysis on each. The first issue in Morgan tackles confidentiality. The parties are engaged in a fairly significant battle over not only what is to be marked confidential and subject to an order, which is common, but more so, where is this information going to rest? Where is it ultimately going to be held? And what are the concerns about security? Disclosure to third parties, potentially, who else will be able to access it? And most importantly, will it be used in a large learning model down the road where confidential information was gathered in an unrelated litigation? Federal Rule 26b-3, work product. Everyone's familiar with its application. The court had a short divergence in this case concerning the application of 26b-3 for a pro se litigant. Basically, the court comes down and says, even where there is some divergence of opinion, that 26b-3 applies equally to pro se litigants. In Morgan, the court is not only dealing with parties exchanging confidential information, but it goes a step further. Now, the parties are challenging each other on the use of the AI platform, and the defendant is pressing the issue. Where is the plaintiff going to put this information? The security concerns around third parties gaining access, and whether or not that information is going to be used down the road on a larger basis by the AI platform itself. Morgan's an interesting decision that grapples with two competing proposed orders that protect the rights of the litigants. The court has to decide, are safeguards required? In other words, is it necessary to place in the order that the AI platform will be identified and it will be a closed environment? This is important because a pro se litigant and potentially other litigants and other lawyers are going to want to use a varied host of AI platforms. And now we can see in the decision in Morgan, the courts are leaning towards closed AI environments where the information will be secure and parties can have reasonable expectations that the information will not escape to anyone outside the litigation. It will not be used by a platform for any other purpose outside the litigation, and potentially even be retrieved. Plaintiff ultimately attempted to argue unsuccessfully in Morgan that the disclosure of the AI platform was unnecessary and the safeguards that the defendants were seeking were overbroad. The court ruled against the plaintiff and basically said, one, the protections should be in place. This is an important ruling given that now the courts have some precedent to lean toward closed AI models when we know there's a host of open platforms available. And secondly, and also very importantly in the decision, plaintiff was required to disclose the specific platform that it's using. In other words, no work product protection and no mental impressions or those such types of protections that we would commonly see be argued given your choice of platform. The court was not persuaded. Essentially, when selecting a platform, whether it be ChatGPT or Claude or Gemini or any platform, that won't make a difference as a protected mental impression. In addition, we can expect to see court orders that expressly limit the use of the information by the software platform and that the environment is closed and that ultimately the parties have long-term security and that it will not be used for a purpose outside the litigation. Take a look at the decision. Any questions, please email me, kroberts@bracheichler.com.